Welcome to Legal Training for Navy JAG, serving as Special Victim Counsel representing child victims of sexual assault, co-sponsored by the ABA Center for Children and the Law and the ABA Center for Professional Development.
Stephen J. Kelly is an attorney. He's a victim survivor who is recognized national leader in pursuing creative justice for crime victims by representing victims in criminal and civil cases. Steve became involved in the victims' rights movement after his older sister was murdered in 1988. Steve is a 2003 honors graduate of Georgetown Law School, and prior to law school, helped to find a first-of-its-kind program matching crime victims with attorneys as a program director at the then Stephanie Roper Foundation. Steve served as a law clerk to United States District Judge Richard Bennett, served as a litigator in one of Maryland's largest and most prestigious law firms prior to starting a crime victim litigation practice at Silverman, Thompson, Slutkin, and White, LLC. Governor Martin O'Malley in Maryland appointed Steve as commissioner to the Maryland Criminal Justice Injury Compensation Board in 2009. Steve has been honored for his work for crime victims by the American University and National Crime Victim Law Institute, the governors of Florida and Maryland, the Roper Victim Assistance Academy, and the Maryland Crime Victim Resource Center. In addition to his memberships with the National Crime Victim Bar Association, Steve serves on the board for the Maryland Crime Victims Resource Center and on MAD, Maryland's Operations Council. He is an active supporter of the Maryland Sexual Assault Legal Institute, the Network for Victim Recovery, D.C., the National Alliance for Crime Victim Rights Attorneys, and the American Bar Association Victim Committee. And with that, I am happy to turn it over to Attorney Stephen Kelly.
Good morning, everyone. I'm here in the city of Baltimore, and we're in mourning for the loss of our beloved Orioles yesterday. But if anybody's in Kansas City, congratulations on an excellent championship. I'm here to talk to you about this crazy concept of being a victim's rights lawyer. And the first thing to keep in mind, and that you will quickly know if you haven't been introduced already, is that your client is not a party. Everybody will want to remind you of this immediately as soon as you enter the scene, the judge, the prosecutor especially, and the defense attorney. So what I'm here to do is sort of, from my experience representing crime victims and specifically children in court, both as a guardian ad litem and victims' rights attorney, is to give you a flavor for how you deal with some of the practical difficulties. Julie and Joanne did a great job of sort of setting forth the skills that you'll need on working with your clients, and I'm going to focus on sort of the legal practice. The two questions that I get from new lawyers who are doing this kind of work is, how do I know where to stand? What do I have standing to assert? What can I assert versus the prosecutor? So hopefully I'll give you a little bit of a flavor for that. First of all, understand that even though your clients are not parties to the case, they do have certain procedural rights. And the rights are contained in various places, but these are essentially the important right. The right to be informed of all relevant proceedings, the right to be present, the right to be heard, the right to restitution, protection, privacy, and confidentiality. And I'm going to talk to you about issues that arise commonly with these types of rights, but these are essentially the procedural rights. And we're not going to have time to go through them all in detail, but what I want to do is let you know that there is a body of law out there that can help you. Fortunately, with the Crime Victim Rights Act and the enactment at the federal level, there's a lot of litigation that has happened at the federal level that I think would be useful to you all. And there is a wonderful website, which I've included in the slides, www.victimlaw.org, which is a very easy resource guide for attorneys on victims' rights. It has a pretty up-to-date, although not totally up-to-date, database of cases and statutes on every topic that you can imagine from, and you'll see it at the bottom of the screen here in the slides, all the different rights, or, you could search by the type of right, you can search within the jurisdiction to find out, what courts have said about whatever issue that you're encountering in the victims' rights world. So you're not starting from scratch. This is a new frontier in the law. And, one of the frustrating things is that you will be pushing the envelope because, the criminal justice system, as many of you are aware, is a very closed insider-type place, and you are, by necessity, an outsider. So to the extent that you can find legal precedents to arm yourself with and show judges and prosecutors and defense attorneys that other courts have recognized these rights and there's been extensive litigation about these rights, that will only help you. Also, in addition to the legal resources, there are networking resources, which I would encourage you all to take advantage of. The National Crime Victim Law Institute is a network of victims' rights lawyers. I call them the ACLU for victims. They're a very good group of lawyers who provide technical assistance to victims' rights lawyers. They provide assistance with appeals. They provide amicus support. I would encourage you all to get in contact with them about any issue that you have. The same issue goes for the National Center for Victims of Crime. They have a network of civil lawyers who represent child victims, which is a great resource for anybody who has a potential issue in either a civil suit for damages or in an ancillary case involving, guardianship or custody or anything like that. They are a great resource. In addition to the lawyer resources from the National Center, there are resources, with regard to the apparatus that supports the criminal justice system. In every state, there are victim rights advocates in most of the prosecutors' offices. In many cities and states, there are victim advocates within law enforcement. And, a lot of these groups are federally funded. They're independent nonprofits. Every jurisdiction has a child advocacy center. These are many times include mental health professionals and others that you can loop into. And I would encourage you all to figure out where those resources are, in your jurisdiction, and to try to tap into them to the extent that it's possible and good for your client. The most important thing for you to do, and this is, applying the skills that Julie and Joanne both talked about, is figure out what your client wants to do. The thing to keep in mind about victims' rights is that they're very weak. A lot of people say they're a toothless tiger. They're a right with no remedy. That's not strictly speaking true, but what you do need to keep in mind is that because victims' rights are relatively weak and are vastly outweighed by defendants' rights, you need to be very proactive in your approach. You need to figure out what rights are at issue and to do everything you can to prophylactically assert those rights and protect those rights. The first step in doing all that is to sit down with your child victim and or other resources like therapists, the parents, and keep in mind the privilege issues that you have to deal with. Work those things out in advance, but get as much information about what it is that your child is afraid of in the process and what your child wants to get out of the process, because you need to map out your plan as to what rights those wishes are going to implicate and how best you can go about protecting those rights. The first thing that I tell folks is, as a victims' rights lawyer, you need to get in touch with the prosecutor, and you need to do your best to make the prosecutor your friend instead of your enemy. Prosecutors are very reluctant to have folks like us come in. I've had tremendous hostility from the very beginning with most prosecutors. They think that you're trying to run their case. They think that you are going to make their life more difficult. Some prosecutors fear that you're going to resist their normal practice of offering plea deals, which you may have to. But the best thing for you to do is to call the prosecutor, reach out to them, let them know that you're here as a resource. You can serve as a conduit because you can communicate not only with the child victim but with the child victim's therapist, with others, and you don't have the same kind of Brady obligations that the prosecutor will have. The prosecutor has an obligation in discovery to turn over a lot of communications. You can act as a conduit by sort of buffering between the child and the child support network and the prosecutor, and thereby, protect a lot of the confidential information that your client has to offer. And prosecutors often see that as a benefit. You want to find out as much as you can about the defense attorney. What kind of person is this? One thing to keep in mind about defense attorneys is good trial lawyers will not attack child victims at trial. Everybody knows that. What people don't realize is they'll do their damnedest to attack your victim every step of discovery. And they try to intimidate your victim through obtrusive discovery mechanisms and through, basically just making the victim, the child victim, and the child victim support network nervous about the level of invasion of privacy and the difficulty of the process. And there are things you can do to shield that, but you want to find out from the prosecutor whether the defense attorney has indicated any interest in doing that sort of thing. Immediately enter your appearance. I don't know if there's a procedure in your practice for doing that, but I encourage you to, in whatever way you can, to enter your appearance and file a written document that, whereby you're demanding all of the rights that your client wants, and, the right to be informed, the right to be present, the right to be heard. Most states have forms that, in Maryland we have what's called a victim notification request form. I have a form. I'm happy to provide it to anyone that needs it or wants it, that basically just says that I preserve my client's rights. This is really important because, as I said, rights are often without remedy. You can usually not stop a proceeding as a victim. You can usually not reopen a proceeding. So the best hope you have is to make the court aware in advance that you want to assert your client's rights and to have that in writing on the record. Your appearance is important because you want to make sure that your client is absolutely informed of everything, every aspect of what's going on, including plea negotiations, including any ancillary proceeding. You need to be informed about it. And to the extent that you make a record with the court, you increase the chances that you're going to be informed about it. Here are some just common issues that I see in my practice, and I think they're the most common issues. The first issue is the privacy of the child not being protected through redaction. Most federal rules, and I'm sure your rules, require redaction. And a lot of lawyers are good about redacting names and identifying information about the victim. That not only means the victim, but if the victim is identified as a relative of the perpetrator, for instance, the son or daughter of the perpetrator, you may also ask the court to either use a pseudonym or redact the name of the adult, because identifying the father will identify the child. So you can be aggressive about this. There's great law out there protecting the right to redact. The other thing to keep in mind is that oftentimes prosecutors especially will redact court documents, the facial documents, but they will not redact things like affidavits in support of search warrants. So you need to look through all those documents when you get into the case and make sure there's nothing on the public record that has your child's name or identifying information. And the authority is there, 18 U.S.C. 3509. This Duncan case in the Third Circuit, just two examples of aggressive laws protecting, the need for privacy in terms of court documents. Testimonial accommodations. This is a really huge issue. Child victims have the right to seek testimonial accommodations, and you should, for most of the victims, they will want testimonial accommodations. Prosecutors will resist you in doing this because they want the jury to see the child testify. And many times that's not good for the child. Testifying in open court, looking straight at the perpetrator is oftentimes not good for your client. There's a whole body of law that is set forth in Maryland versus Craig, which I have here, Supreme Court case 497 U.S. 835, that talks about the fact that you can present the court with evidence that your client is afraid of the perpetrator. And as long as there's some competent evidence of that, most courts will allow things like video depositions, two-way CCTVs and that sort of thing. And 18 U.S.C. 3509 codifies that for federal child victims. So I would encourage you to talk with your client about testimonial accommodations, to think about that issue early, and if you're going to want testimonial accommodations, try to get consent of the prosecutor in advance, and if you can't, file a motion early, well in advance of trial, so that you have a testimonial accommodation. That issue is put to bed, because that's a very important issue for a child victim. One thing, going back to the first question about where do we stand, when you're asserting one of these rights, the thing that you want, your goal should be that I want to stand with the prosecutor, because you want to have the prosecutor on your side if possible. If the prosecutor will not take a positive position on your client's position, so if they won't support your motion, if the prosecutor won't make the motion, then at least try to get them to be neutral. If the prosecutor is supporting you in your position, then you could stand at trial table with the prosecutor. If the prosecutor is taking no position or is taking an adverse position, then ask in advance to have a separate desk put in the courtroom for where you're going to stand and address the court, because it's important that you want to physically show that there is a divide between me and the prosecutor. It puts pressure oftentimes on the prosecutor, but you want to deal with that issue in advance because you don't want to be in a situation where you don't know where you're going to be standing in the courtroom. So that's it seems like a little issue, but it actually can be a very important issue, and you want to be strategic in the way you deal with it. Attempts to exclude the child victims and you need to be prepared, especially the first time you go to court, to tell the judge what your client's right is in terms of your client's right to be there. And with this, I'm talking about most victims are exempt from the sequestration rule, so that that's a common tactic of defense attorneys, to call the rule on witnesses and to exclude anyone who's testifying, including the victim. In federal law in most states, there are exceptions to the sequestration rule for child victims, and so you want to be aware of what the law is and to be armed with that. You also want to be armed with any authority about your right to speak on your client's behalf, because defense attorneys will oftentimes object to you being able to say anything to the court, and the fact that you're even allowed to enter your appearance and be heard at all, they will object to, and they will always raise standing issues. Do you have the standing to present this issue, or does this have to be presented by the prosecutor? And so you need to be prepared to address those. The final aspect here is the intrusive discovery. This is becoming more and more common, where defense attorneys will seek every record in a child's schooling. They'll seek Facebook, Twitter, everything, every kind of social media that you can imagine. You want to be prepared to resist these types of third-party subpoenas, and you want to be on top of what the prosecutor is turning over, because prosecutors oftentimes won't tell you, and you need to figure out very quickly what it is that the prosecutor has and what they intend to turn over. And you could file a motion with the court seeking at least a protective order as to what's done with the information, whether it's shared with the perpetrator or defendant, or preventing the prosecutor or a third party from turning over information that pertains to your child victim. And I would encourage you to go on the NCVLI website, which I gave you in the earlier slide, and there are pleading banks there about motions to quash subpoenas, form motions that rely upon the Roe v. Wade privacy rights, but also rely upon state and federal statutory protections for child victims. This will allow you to really prevent, the kind of re-victimization and re-traumatization that defense attorneys are oftentimes trying to inflict upon your child. The last, thing I really want to address here is the victim impact. And one thing to keep in mind is there's a real divide between the procedural rights that a child victim has, or any victim has, during the innocence phase of a trial and the post-trial rights. When you're talking about the innocence phase, you're talking about, constitutional rights of defendants, most times really rolling over the victim's rights. Post-conviction, it's another matter. In the post-conviction, you're talking about the rights of a convicted person against the rights of a child victim, and oftentimes you will score major victories in asserting rights post-trial. The thing that I like to say about post-trial rights is there are two real goals to victims' rights. The first one is to protect your child from re-victimization. The second one is to give a face and a voice to the victim. The state is a cold, hard entity, in military, wherever. And your job, the thing that you can do to really influence the process, as long as your client's on board with it, is to bring your client to life for the court. And the best way to do this is through victim impact. Victim impact is, in my practice and experience, critically important. It can be absolutely a difference maker, for both in terms of your child victim and their feeling about the process and how it went, and in terms of the players in the system and how they feel. So I would encourage you to meet with your client, to gauge your client's interest in doing victim impact. One thing to keep in mind is courts are very, very liberal for the most part on allowing accommodations. They allow the child to sit on the lap of a mother or a supportive person. They allow all sorts of creative accommodations at sentencing because the same rules don't apply as the guilt and innocent phase. So one thing that I find important is if your child victim is not going to speak directly to the court, use video or pictures. The court really needs to understand that this is a person who has been impacted. And, the defendant will be all over that in terms of presenting themselves as a human and begging for mercy. Your job is, as a counterweight to that, to demonstrate to the court, here's the impact, and here's the person who's impacted, and here's how they were impacted. And then just a brief word on restitution and financial stuff. I find that, first of all, you should keep in mind that most victims have no hope of recovering any money from anywhere other than through restitution. Restitution is there for a reason. The law is expanding tremendously. There's been a lot of changes in the law. I encourage you all to go on some of the websites that I gave you and take a look. There's a Supreme Court case last term about restitution for child victims and child pornography cases. So the law is expanding to really require offenders to pay back victims for things like future counseling expenses, future lost wages even. And those are really encouraging developments in the law. An effectively presented restitution request in a criminal case can really add to the victim impact portion of the presentation. So you're demonstrating to the court the emotional impact and the financial impact, and that can have a dramatic impact on how the child feels about the whole system and the way it went, and how the court deals with the offender in terms of sentencing. So that's all we have time for. I gave my contact information. I would encourage anybody who needs forms or needs practical advice to reach out to me. I'm happy to help in any way that I can.
Great. Thank you so much, Steve. That was really helpful. And, as far as, especially on behalf of the ABA, we're always so grateful to have attorneys like you who are willing to share your expertise with folks who are practicing in this area as well.